Hi, I'm Daniel Smith, supervising attorney. Today we're talking about the process that's involved when you are defending a client that's been charged with a crime. And let's say that client is you, and you've been charged with a DUI. And we have talked a little bit about what happens at the first court appearance, where we enter a plea of not guilty, and then the second court appearance where we are involved in what are called settlement negotiations in what's called a readiness hearing. So the next thing that might occur in a case like this is that we are really going to get down to brass tacks. What do we want out of the case? Now, there may be many cases, many situations where we're looking for something for our client that's something less than a DUI, for instance. You've heard of the expression wet reckless and dry reckless and things like that. They do make a difference. For instance, a dry reckless would count in many cases as 2 points in your license, but it does not involve alcohol. There are lesser classes that you have to take. One is called the educational class, but I'm kind of getting ahead of myself here. What we're really talking about is the negotiations, and when they get a little bit further past that first set of negotiations, and we're really trying to come to a resolution. What do I want? What do they want? What are the strengths of my case? What are the strengths of their case? It's very important that your opposition, the prosecutor, knows that you're a trial attorney, that you're the type of attorney that will go and take them to the mat. That is going to be an important factor when they determine whether or not they should consider the offer or what you are negotiating for. So let's take a situation where I've got a client. Let's say that he's parked in a legal parking spot. He's at a .26, and that's very intoxicated, over 3 times the legal limit. But in that particular case, the client, let's say, has not driven. The cars are, the keys are in the ignition. The car's running, but the officer says, "Where have you been?" He says, "Here." He says, "Have you been drinking?" He says, "Yes." And the officer says, "Where have you been drinking?" He says, "Here." And the officer then asks, "Where are you going?" "Here," he responds. Okay, there's a driving issue here that the prosecution has to overcome. Now, in many cases, the prosecutor may say, "Well, look, I'm not going to give you a DUI in this case, but I'll offer you a wet reckless." Well, I might come to the prosecutor and say, "No, that's not acceptable. I would look at a dry reckless in which alcohol would not be a factor in the case, which may mean a lot down the road when it comes to getting a job." Now, if that prosecutor knows that I will take him to trial, that I will take him to the mat, he or she is really going to consider that in the case. It's important that they know that you are a trial attorney, that you will get out there and you have charisma, you have the ability to talk to the jury. That's what we have here. That's what we have with our firm. We roundtable the cases, we talk about them, we simulate the cases in many situations. So we want you to know that when we go in there to negotiate on your behalf, they know that we're serious and we'll get what we're asking for because they know we're trial attorneys.